Good afternoon. Welcome to the Environmental Law Institute. You've joined us for the summer school series, Basics of Land Use Law. My name is Caitlin McCarthy, and I'm the Director of Education, Associates, and Corporate Partnerships here at ELI. We're delighted to welcome everyone here today to the fourth seminar of ELI's annual summer school series, and I encourage you to join us here at ELI every Tuesday of next month as well, except for next Tuesday with 4th of July for summer school. For more information, please see our events page on our website, eli.org. Thank you for joining us. At the end of today's panel, we will have time for a question-answer session. If you're joining us in the room, we have this microphone to bring around. Please ask your questions then. And if you're joining us via GoToWebinar, please submit your questions through GoTo's question box, and please do not hold off until the end. Send your questions as soon as you think of them. I would like to thank our outstanding panelists for joining us today to lend their leadership to summer school. While I will introduce them briefly momentarily, the full speaker bios are posted to our website, eli.org, and I would encourage you to check out their expertise and experience in more detail there. So as we begin, I would like to warmly welcome Heather Dlhopolsky. She's a partner at Linowes and Blocher and is part of her firm's land use and zoning practice. She works on all matters of land use law and zoning issues for projects including mixed use, multifamily, and commercial projects. Heather, thanks for joining us. Sarah Everhart is an adjunct professor, research associate, and legal specialist with the Agriculture Law Education Initiative at the University of Maryland Francis King Carey School of Law. Her areas of expertise include land use law as well as labor law and environmental policy. Sarah, thank you for returning to summer school. And Diana Norris serves as the in-house counsel for the Piedmont Environmental Council. She's an experienced litigation manager and has a demonstrated history of working in nonprofit organization management. Diana, we're so happy to have you back at summer school. Thank you. Our fantastic panelists, thank you so much. And Sarah, we'll turn things over to you.
Thank you, Caitlin. Okay, so yes, I work for the Agriculture Law Education Initiative, and basically that means I do legal education and outreach with the agricultural community across the state of Maryland. So if agricultural law is something you're interested in, I would encourage you to check out our website. It's umaglaw.org, and I'm also a professor at the Carey School of Law, like Caitlin said. Okay, so I get the job of starting us off today. So who owns property in the room? Raise hands. Who wants to own property in the room? Okay, some of you have no interest in owning property. Okay.
New world.
Well, whether you own property, whether you one day hope to own some property, you're all living on some property, working on property, right? So we all have different vested interests in property. And we, right now in 2019, have a very complex network of planning and zoning laws nationally and within our state. And they're on the federal, the state, and the local level. So we're just going to walk you through that network and hope you gain a better understanding of how all these pieces work and function together. In the beginning, we didn't have a lot of complex zoning laws. We had some city planning. And most land use disputes were resolved with nuisance laws. I don't like what my neighbor does. His pigs are stinky, and that's ruining my life. It's ruining my ability to use my summer house. And then restrictive covenants. So we had restrictive covenants going back a long time. We love to be able to tell other people what they can't do on their property. And so that hasn't changed over time. Zoning laws came about in order to prevent some of those nuisance actions. So we all know we're trying to keep those dockets light. There's a lot of things that have to go to court. Try to create laws to give people an understanding of what they can and they can't do with their property, so we reduce some of those nuisance fights. Land use law is really a balancing act, and it's a balancing act of a person's right to use the property, their property, versus the impact of that use on another's right to quiet enjoyment. So when we own property, when we're renting property, we all have the right to be there, we all have the right to use it, but we have to make sure that that use doesn't ruin someone else's right to use the property. And that's really what land use law is all about in a nutshell. So I will start with some of the constitutional underpinnings, and these are really sort of a kick the can kind of thing, as you'll see. So what part of the Constitution allows states to regulate land use? Does anybody know? No, everybody's deep in their lunch. It's actually the 10th Amendment, and it comes about because the powers that aren't specifically delegated to the federal government are reserved for the states or the people. So because the Constitution doesn't really get into land use law, that's where the states get their authority to have such power in terms of land use law. States have the power to regulate in order to protect the public health, safety, and welfare. Those are big words in land use law. We refer to those as the police powers. So if you take a look at land use legislation, you'll see a wide variety of different types of things that folks regulate through laws, and they always say they're doing so to protect the public health, safety, and welfare, because that's what the states have the right to do. They have the right to pass laws to protect those things. Kick the can because the feds kick it down to the states, and in most situations, and definitely in our area, the states kick it to the local jurisdictions. So in most situations, states don't want to get involved in land use issues. They see it as a local issue. They think that localities have a better idea, better understanding of what should be going on with individual property rights. So the local jurisdictions have a lot of power, which is something that's fairly unique. Can't really talk about land use law without talking about due process. So we've got a couple different forms of due process. Due process applies to the federal actions from the 5th Amendment, and then applies to state actions through the 14th Amendment. But basically, we've heard this before, we all know, that states do not have the right to deprive any person of life, liberty, or property without due process of law. Okay, so what the heck does that mean, right? So we know we have a right to due process. Hey, states, hey, feds, you can't take anything away from me without due process. Let's break that down a little bit. So what does due process do? Due process, I really think about as fairness. It ensures fairness. And in the land use context, it comes into how a regulation is adopted and how a zoning decision is made. That falls under procedural due process. So you have the right to know about how zoning decisions are being made. You have the right to notice if a land use or zoning law is being passed in your jurisdiction. That's why these things are still advertised in the paper. That's why this is a very public process. You can walk into your local planning commission meeting and sit in the back. You can go to every one. And the other type of due process is substantive due process. So in the scope and implementation of the zoning regulation. So what types of things can a local jurisdiction pass a law dealing with under the auspices of land use law? We know that they have to be related to those police powers, but when do they extend or go beyond that permissible scope? So it has to be fair in those two ways, and that's what the due process, that's what our due process rights ensure for us. So citizens have the right of pending government actions, public hearings, like I said, cross-examination. So if your neighbor has to go in front of a local zoning body, you have the right to ask questions. You have the right to speak in that hearing. Creation of a record. There needs to be a record created, and we'll talk about that in a few slides here when I talk about appeals. There should be a written determination. So the body has to come up with something in writing as to why they made their answer. They have to explain how they reached that conclusion. And then you have the right to appeal. If you have standing, you have the right to have that decision appealed. Substantive due process, like I said, is really about whether the land use actions substantially advance a legitimate government interest. So yes, you have the right to pass this law, but is it substantially advancing a legitimate government interest? Can you tie it back to health, safety, and welfare, those police powers? To succeed on a substantive due process claim, the plaintiff has to establish a couple different things. That they actually have a property right rooted in state law, which sounds kind of common sense. Why would you bring a lawsuit if you didn't have a property right to protect? But actually in land use law, this gets very complex when we're talking about vested rights. And I'm sure Heather can talk about this more. But if you have a land use project, if you're trying to develop a piece of property, when do you have a right that is vested? When do you have a right in that zoning that's vested? If you buy this piece of property and you want to make it into a self-storage unit, and you go down to the local zoning office and you say, is this permitted in that zone? And they say yes, and then you proceed with the development. Is that right vested? What about if the jurisdiction changes the zoning halfway through the project and then you want to go to court? Did you actually have a property interest? When does that right vest within the process? When you're talking about simple things like residential development, a lot of times people spend a lot of time and money. Lawyers spend a lot of time trying to help people, you know, build the house of their dreams. They get everything approved on paper, but until they break ground in Maryland, those rights might not be vested. And despite all that effort and money they've put into that project, their rights may or may not be vested. So that's really when that comes into play. The second part of the substantive due process claim is you have to prove that the government deprived you of a property interest in a matter that was so far beyond the limits of legitimate governmental action that no process could cure the deficiency. It's a hard standard. It's a difficult claim to bring. Another constitutional protection that comes into play when we're talking about land use law is equal protection. So in zoning law, we love categorizing things, right? That's what zoning is. We make up a bunch of different categories and we try to fit all these new uses within these categories, divide the whole jurisdiction into different categories. With all that categorization, there needs to be a recognition of equal protection. So the equal protection rights provide that nor shall the state deny to any person the equal protection of its laws. And we're allowed to classify things, okay, as long as those classifications are rational, non-arbitrary, and reasonable in relation to the objective of the law. So we can create zoning classifications. We need to treat everybody within the zone the same way. That's where equal protection issues come up. When people within the same classifications are being treated differently, they may claim that there's a denial of equal protection. Excuse me. And always with equal protection, we need to be cognizant of suspect classes. So anytime a classification is being made based on race, national origin, or one of our fundamental rights, First Amendment rights, there could be a deprivation of equal protection. Takings. So Diana's going to talk in much more detail about takings, so I won't go too far into this, but we have the right to have compensation if the government takes our property. They can take it, but they have to compensate us for it. And that comes from the Fifth Amendment and then applies to state actions through the 14th. A couple different types of taking. There's a physical taking, a regulatory taking, and regulatory takings are the more common claims in terms of land use law. Hey, jurisdiction, you created this really complex network of regulations, and in so doing, you took my property. You took something of value from me. That regulation took my property, and you can't take that property away from me unless you compensate me for that action. So there's been a lot of regulatory takings cases in the last couple of years. We would have to be here until the 4th of July to go through all of it. But in a nutshell, in order to succeed on a regulatory takings claim, you have to have a regulation or a decision that deprives the owner of substantially all economic beneficial use of the property. So a lot of times clients get mad that they don't like the zoning, that it's going to curtail their use. And this is one that they love to run into a lawyer's office and say, I've got a takings claim. I want you to sue the town. I want you to sue the county. I want you to sue the state. I can't do what I want to do on my property. Well, can you do something on the property? Does this law take away all economically beneficial use of the property? Because that's the standard that you're going to have to be able to reach to be successful on that claim. I mentioned this case. This is the seminal zoning case, Euclid versus Ambler Realty. Excuse me. And this is why we call what we come to know now as traditional zoning Euclidean zoning. And if you can pronounce that right, that might help you in your land use law interview. See if you take nothing else away from this. But that comes from the Euclid case. And this case is important because this was the case in 1926, where the Supreme Court looked at traditional zoning regulation and said, this is not a taking. Splitting this jurisdiction up into these zones, telling these people who own this property what they can and can't do in these zones, the fact that it's reasonable, the fact that it was passed pursuant to a police power, As long as it's not arbitrary or capricious and it's for the protection of the public health, safety, and welfare, it's not a taking. After that case, that's sort of when zoning went wild. When then everybody was watching to see what would happen, and then once the Supreme Court said that's fine, it's not a taking, then across the country people passed these zoning laws. All right, so I told you this was mostly done on the local level, and that's true, and it's important, and it makes your job as an attorney a little bit more complicated, because local governments don't have inherent power to regulate land use. Remember, the can was kicked, so they kind of got this by default, and you have to look at the state enabling authority to figure out where these powers are coming from and what's the extent of the power. It's important. It's confusing. In Maryland, it's confusing. We have a lot of different types of counties. We have code home rule counties, charter counties, commissioner counties. You got to figure out what type of county you're in. You have to take some time to look at your state enabling authority. A lot of other aspects of legal practice, people are not looking at state enabling authorities, but in land use law, we do, especially if you think that someone has overstepped their authority to pass a law. So one of the reasons why it's important is because we have different articles in the Maryland Code, and I know not all of you will be practicing in Maryland, so I won't go too far into this, but you have to figure out if you should be looking at the local government article or the land use article. And there's also other laws that you need to look at for authority as well. We have water and sewer planning, stormwater management issues, forest conservation issues, non-tidal wetland issues, a variety of things. So you will not be sticking with one article of the Maryland Code if you practice land use law, or really, I would think in many different jurisdictions. It's a fun but challenging part of this type of practice. Some lawyers only look at one article of the code for the rest of their work, and that's not the situation with land use lawyers. They have to think about a lot of different factors. We have a couple different basic zoning tools that the municipalities and counties use to control their land use within their boundaries. Heather's going to go into some of these. I'm going to talk about comprehensive plans. So how many of you have ever read a comprehensive plan? Oh, all right, a few of you. And you stayed awake throughout the reading? For what jurisdiction did you read a comprehensive plan?
I studied some plans in schools.
Okay. You had a bunch of different ones. All right. They are interesting animals. So this is the planning part in Maryland with the planning and zoning. So comprehensive plans, they're legislatively adopted like a law, but they're not a law, but they have some power, as we'll talk about. And so they're typically created at the Planning Commission level. So the Planning Commission starts working on these. You have to do them every 10 years in Maryland. They start them about 2 years out of when they're due, because that's how long it takes them to pass these things, to create them and pass them. They're oftentimes lightning rods. They will be large meetings, even in small jurisdictions. They can have, you know, weeks and weeks and weeks of public meetings, and people want to make sure that their property and the property around their property is designated in the proper way. And really what they do is they're forward-looking documents. So they say, here's all the land in our jurisdiction, here's what it's devoted to now, and here's what we want it to be devoted to in the next 10 years. So what's happening now, and then looking forward into the future. Spelling out development, they're going to include maps. The maps in them are very important. The verbiage is important, but the maps are also very important too. And it's not just residential, commercial uses. It's things like transportation, community facilities, natural resources have become a very hot topic in them. Going to have policies for protecting environmental features, and the reason that they're so important is because there are places within the Maryland law that consistency with that comprehensive plan is required. So they're not the zoning law, they're the planning document, but they have to be referred to quite often. So when you're passing zoning ordinances, when you're applying and granting special exceptions that Heather will talk about, water and sewer amendments, critical area growth allocations. So if you're a land use lawyer, you will have a couple comprehensive plans on your back bookshelf, and they'll probably have a lot of stickies in them because you'll have gone through them for your clients. And if you represent clients who have property, you might have to go to all of those meetings and babysit the plan and make sure your client's property is designated how they want it to be designated. It's a pretty interesting process. So if you're interested in land use law and you see an advertisement for, hey, we're starting the comprehensive plan process, it would be worth going and watching and observing. You get a good idea of the politics in the town. You get a good idea of, what the plan is for the future. In priority funding areas, and that's municipalities within the state and then inside the Beltway, land uses and densities have to be further and not contrary to certain parts of the comprehensive plan. So it's really something that sometimes people who don't understand planning and zoning don't really understand the full power of this document and don't really appreciate how important it is. They go in, they find their zoning, they say, oh, good, I can do what I want to do because I'm good with the zoning, and then they move on and they don't think about the other part, which is the comprehensive plan, which can be really important. Okay, so hearings and appeals, I kind of referenced this, but this is an interesting part of land use law and something I really liked, but I think it's definitely a unique aspect of land use law. We're kind of the Wild West in terms of our hearings and appeals. Depending on where you practice, it can be a little bit different. But in general, zoning bodies are not bound by the technical rules of evidence. So all those rules of evidence that you learned in law school, good to know, because a lot of times citizens will try to invoke them. I have had people scream hearsay at me at a zoning hearing before. I think it was too much Law and Order watching. But they're not bound by the technical rules of evidence, which can make things a little bit easier in some situations and a little bit trickier in other situations. The challenging things for attorneys when they're representing clients, well, in my opinion, one of the challenging things is thinking about building a record in a non-formalized environment. So sometimes it seems like you're going a little bit over the top, especially if you're representing a client on something in front of a zoning body and there really isn't any opposition, which sometimes happens. Sometimes you get lucky and there's not opposition and you don't think anybody's going to be there. But you still have to bring in exhibits and build the record and prove all of the evidentiary standards that are in the law that you need to prove. Even if it's the night before the 4th of July, even if everybody on the hearing board's like, come on, even if it's 9:30 at night, a lot of times these zoning boards are staffed by, in some cases, in rural parts of the state, they're staffed by, these aren't lawyers necessarily. Sometimes they are, a lot of times they're not. And so they don't really have a full appreciation sometimes of how important building the record is. And I'll get back to building the record in a second. But how to appeal? So a lot of times, because these can be somewhat informal hearings, the client doesn't call you at the hearing. They call you when they want to appeal, because then they're not happy. They call you because they thought they could do it on their own, and then they realize they need a lawyer real quick because they don't like what happened, or they don't like what happened to the piece of property that's going to affect their piece of property. So they came out because they saw something in the paper, their neighbor had a sign in their yard, and then they're freaking out because they don't want that to happen. So how can we appeal this? Well, you have to look to the law. It's very specific, your right to appeal. Sometimes there's very short turnaround times on some of these. So you really have to move if you're going to take that appeal. And you got to figure out if your client has standing to appeal. Sometimes, people feel very strongly about their community, and they use the word community to mean a large jurisdiction, a large area. But are they actually a nearby or adjoining property owner? Are they so far removed that they wouldn't actually have standing to appeal? Those are complicated issues in land use law. And it's important to figure out if you've exhausted all your administrative remedies prior to appeal. So a lot of times there's some administrative steps. Maybe the planning director gave the final decision that you want to appeal, but do you have to appeal to the Board of Appeals before you can file in circuit court? Clients don't like that because they don't really understand that, and it's going to cost more money and it's going to take more time. They're like, let's go to court. Well, they're not going to like it if you end up in court and you get kicked out of court because you failed to exhaust your administrative remedies. So sometimes you got to jump through some of those hoops. Standard of review, here's the good news. Standard of review is these are for quasi-judicial decisions. This isn't legislative stuff, but quasi-judicial decisions. So if you're in front of a hearing body and you get a decision, they're typically reviewed based on the record created below, and the standard is the substantial evidence test. So if you were, it's good news if you were successful below. So if you were successful below, the court is going to review that record, which is why I told you to build that record, because you got to build that record to protect yourself and protect the decision. And they're going to decide whether the factual findings that led to the decision were based on substantial evidence. So could reasoning minds have made this decision? If reasoning minds could have made this decision in a light viewed most favorably to the agency, so to the jurisdiction, then they're going to agree. For the most part, courts don't like to get in the middle of these types of things. They like to have the local jurisdiction be the one that made the decision. Those people that are on that board, they live in that county, they understand these issues, they drive by that property, they know what's best for that property. So if their decision seems like a sound decision, court's going to let that stand. Exception to that is an error of law. So if a board just totally screwed up applying the standards, if they forgot to apply some of the standards, if they reached that conclusion without making all the underlying findings to support it, then we could potentially have an error of law. So here's my little 5-minute plug for land use law. I'm glad you're all here today. I think you would like land use law if you like things that are interdisciplinary. I like it because it's intergovernmental. You get to work with a lot of different types of people. You get to work with people at different levels of government. You often get to work on a team, so you're working closely with developers, with engineers, with environmental experts. You need folks to help you be able to prove all the different things that you need to prove. So if you like working on a team, if you like sometimes thinking about, large scale issues like that, it's probably for you. Recommended resources, Judge Harrell was sort of our famous Maryland land use judge, and this is one of his decisions. County Council of Prince George's County versus Zimmer Development Company. If you need something to read this summer, give that one a read. I think it's a good case, and it kind of outlines some of these basic parameters of land use law. Maryland has a Planning Commission education course, and you can go on and look at all the materials and go through it. I think it's a great way to kind of brush up, and it's just a really succinct place to find answers to these things, and then you'll know what these zoning bodies know because you'll have looked at the educational materials. The Patricia Salkin's Land of the Law blog is a blog you can subscribe to, and she shoots you and the folks that help her shoot you really interesting cases from across the country, so you can look at those. I think it's a good source of information. And then finally, you can attend meetings. So students ask me all the time, once they graduate, oh gosh, I got that land use law job I really wanted, I have my first case, I'm really nervous, what should I do? Go the month before. Go and watch. It's a public meeting, so you will know, you'll have a feeling for how these people rule on things. You'll have a feeling for, what they like, what they don't like, how they're treating the applicants, how they're treating the opposition. So go and observe these stuff. It's really well worth your time. And then you could consider, if you could do this, serving on a planning commission or a board of appeals. So I was able to do this during the economic downturn. There was not a lot of land use law happening in 2007. So in my neck of the woods, so I served on my local board of appeals. And the warning with that is it may present a conflict for you if you're working in private practice, but if you're working in the government or if you're working in another context where it's not going to present a conflict for you, they love lawyers on these boards and planning commissions, absolutely love it. Because like I said, it's often not an exclusively legal group, and you can really learn a lot.
Good afternoon. My name is Heather Dlhopolsky. I'll just tell you a tiny little bit about myself. So probably a lot of you maybe are studying environmental law, and that's why you're here at the ELI. So I actually got my JD and a master's in environmental law, and then promptly threw the master's right out the window because I needed a job to pay my student loans. And so now I've been doing land use law for 13 and a half years, and someday maybe I'll do environmental again. But I really appreciated Sarah's presentation because I have never taken a land use law class in my life. So I learned a lot. But as you'll see as I kind of get into my slides and whatnot, you know, a lot of what I'll talk about is sort of the practical day-to-day of practicing land use law, which I thought Sarah's second to last slide was really interesting about kind of the plug for doing land use. I don't really feel that a lot of what I do is really even land use law per se. So much of it is almost just sort of like project management and sort of just quarterbacking a team. And I think that that's what attorneys do really well. So full disclosure, I tend to represent developers as opposed to like the opposition side of land use and zoning. But when I say developers, I mean really any property owner is looking to do something with their property. So if you own a single family home and you want to put a deck on the back and it encroaches within your rear setback line, you're going to a hearing, and that's when you might call a land use attorney to help. So, you know, and there's a lot of players that go into that. It's a civil engineer and it's an architect and maybe it's a traffic planner. And as attorneys, I think we do a great job of being really OCD and organized. And so it really lets us kind of herd all of the cats and, you know, build that ever important record, as Sarah said. So, like I said, I don't know land use law in terms of academically. Fortunately, I've never been to even court on a case, but I'm going to talk really more about sort of the practical day-to-day that I just do day in and day out, which really I think is probably 95% of what most land use lawyers do. So, so I will interrupt myself several times over with just sort of practical things. So I think Sarah did a great job kind of covering the power to zone and the notion that it's sort of pushed from federal to state to local. Just a few sort of maybe practice points that I would say. Really every jurisdiction is very individual. So if anybody here is from up north, I'm from Long Island. And so something that's really funny to me is that here, not everywhere is like an incorporated municipality. So up north, like everywhere is in a town, right? And so you have your town zoning board, and it's a fairly small jurisdiction. Whereas down south more, it tends to be that you have kind of these very large counties, and then there are several incorporated municipalities within those counties. And each county and each municipality, depending on how much they undertook to implement the enabling legislation they were given by the state, they have different abilities to zone, to plan, to do other things that we'll talk about later in the presentation. So one of the most critical things when somebody comes to you with a property is to say to them, okay, I need the exact address because I need to know if we're talking about the county or if we're talking about a municipality or part of like the unincorporated municipality. So I don't know if you guys know Montgomery County where I practice. There's like the city of Rockville, but then there's also this very large area around it that people call Rockville, but that's really not the city of Rockville. And everybody gets very confused, but depending on whether you're within the line or outside of the line has enormous effects on where you're filing your applications, what you're allowed to do, what you're not allowed to do. So it's very practical just off the bat. I need to know your exact address because you telling me that you're in the city, I can't believe you and you really want me to help you, so I need your address. And then another thing to say just on a practical perspective is it's because of this reason that I think a lot of land use lawyers, we just practice in a few jurisdictions because each jurisdiction has really its very much own zoning ordinance, its own rules. And so I, for example, practice in Montgomery County, Prince George's County, a little bit in the municipalities therein, but that's really all I do because it is so different just to go to Anne Arundel County or certainly to cross over the river. Land use lawyers do not cross the river. Virginia doesn't come here, we don't go there because it's just such different worlds. So it's really very highly local. And like I said, I'm going to interrupt myself and jump around a million times. So that's pretty much what I just said. So always check the address, very important. So I wanted to talk a little bit, I think Sarah did a great job talking about planning versus zoning. So I'll get into a little bit more of sort of the specifics of those. These are types of land use planning and zoning actions. And like I said, we will go into them more. The first three, I'll go into more detail. I think the affordable housing, the historic preservation, planning for streets and roads, that's fairly self-explanatory. One thing I wanted to bring up here is what I indicated as APF, adequate public facilities. And this is something I think that, you know, if you read the papers, local papers, even national papers, whenever there's like disputes over development, I feel like a lot of times it really touches on this. So adequate public facilities are there adequate roads to serve the project? Are there adequate schools to serve the students generated if it's a residential project? Is there adequate police and fire, water and sewer? And these are the types of things that I think folks get very upset about because they think that there's not adequate stuff and it's going to impact the other people in the area. And I think a lot of times the community, you know, thinks that the jurisdictions do not address school capacity and don't address road capacity. But in fact, it is a required finding of most applications, development applications that you file, that you can't be approved until you demonstrate that either there's existing capacity or with the improvements, the public improvements that your project would make. So maybe you're building roads, or maybe you're putting in a new traffic light, or maybe you're adding lanes. You can't be approved until you can show that there is adequacy. And I think sometimes people don't understand that that is something that is actually very carefully evaluated and carefully considered, and projects can't go forward until those tests, the APF tests we call them, are met. So I just wanted to touch on that because I think it's something that's a little hard to understand, but it is very much a part of the process. So we'll go into a little bit more of planning versus zoning. I think Sarah gave a great overview of it. So planning, again, it's broad, it's long-term, it's adopted through a legislative process, but it is not actually law. It's not written into a code per se. And these planning policies are across a very large array of documents. So we can, well, first actually I talk about what is zoning. So, but I think Sarah did a great job of that. One thing I would just say, just in terms of sort of practical pointers, depending on the jurisdiction you're working in. So for example, Montgomery and Prince George's County, the zoning ordinance for each of those is literally double-sided, a binder. It's got to be at least a 3-inch binder, if not a 4-inch binder for each of those jurisdictions. That's their zoning ordinance. And it gets into more detail than you can possibly imagine. Then if you go to some maybe smaller jurisdictions, some municipalities, or perhaps maybe more rural jurisdictions that don't have, both the urban and the rural, types uses, it may just be like a section of their county or city code. So depending on your jurisdiction, you're looking at a ton of paper, or perhaps not quite so much. So land use and planning actions, just wanted to give a sense of the types of these documents. So starting with the big and getting to like the more nitty-gritty, general plan is usually something that would cover like an entire county. So there's a Montgomery County general plan that they're in the process of updating. I think the update is called Thrive 2050. So you can see it's a very long-term, big picture. I see some heads nodding. You're probably familiar with that. Prince George's County similarly has a general plan that they recently updated. So that's sort of a big plan. Then you might get to something called a master plan. And again, I should say these are all examples of the comprehensive plan that Sarah talked about in her remarks. So master plans are maybe for smaller areas. So for example, there's a Bethesda downtown plan. So that's like a master plan. There's a Silver Spring plan. There's a plan for Largo Town Center. Sector plans, again, are getting a little bit smaller than that, but they're still planning documents. So they could be very large. They could go a little bit smaller. And then functional plans have specific, obviously, functional purposes. So you could have a functional plan for transportation. An example of that is there's a functional plan for the Purple Line, which some of you may have heard is under construction from New Carrollton all the way over to Bethesda, kind of providing some east-west connection. So that's a functional plan. Montgomery County recently adopted a bicycle master plan. That's a functional plan. So these are all examples of planning actions and planning documents. So types of zoning actions, we've got a list here. We'll go into each of them in a little bit more detail. And I just wanted to show you guys a zoning map. So maybe some of you, who's seen a zoning map before? Okay, a few. It looks like a bunch of gobbledygook, but it says an awful lot. This actually is for a section of Rockville Pike you could call it North Bethesda, you could call it White Flint, you could call it Rockville Unincorporated, you could call it the Pike District, whatever you want. But this is Rockville Pike. You could see some letters and numbers. The CR is commercial residential. It's a mixed use zone. You can also see some blue on there. That's a planned development. So, you would be looking, and all those lines are individual parcels and lots. So you would look up your address and find which kind of numbers and letters cover you. And that's a great starting point for how you practice land use and zoning law. And I'll just give another example. This is in Prince George's County. It's along 95, so that big kind of white diagonal line there is US 95. You can see you have something called a CO, that's a commercial zone. An RT, it's a residential zone. OS, open space, somewhat intuitive. So it looks like a bunch of gobbledygook, but as you start to get into it, you can see how it makes a little bit of sense. C, commercial, R, residential. And then once you know your zone, and apologies, this is a tiny little bit hard to see, but it gives you an example of the complexity of a zoning ordinance, because this is one page of like 1,000. This is Montgomery County zoning ordinance. And across the top in the colors, again, sorry, it's a little hard to read, those are all the zoning categories. You have like AR, that's agricultural. It tends to get more intense as you go across. You've got the residential categories, the commercial residential, which is Montgomery County's mixed use zone, employment, industrial, and then down the left side, you have a variety of types of uses. And then if you kind of, triangulate, go across for the use and down for your zone, you can see that you have some Ps and some Ls and some Cs and some blanks. So when you have a blank, your use is not permitted in your zone. You have a P, that's great, you're permitted. If you have an L or a C, there's going to be some amount of process. L is limited, C is conditional. So finding out what your zone is and what use you want, and then seeing what letter or blank accords with it. Again, really basic starting points, but basically tell you an awful lot about whether you can do what you want to do. And then another just one pager from the zoning ordinance. This is the bulk regulation. So the previous slide was uses. So your zone, the use you want, can you do it or not? And even if you are allowed to do it, you then need to look to all of these things to, it's the dimensional standards. So site area, is your property big enough to do what you want? If you have like a 6,000 square foot single family lot, your lot, aside from trying to do an urban use on it, it's not going to be permitted, but you certainly don't have enough lot area to put in a big commercial office building. So your site area, open space, typically there's some sort of open space required on the lot. There are usually typically some sort of setbacks, so you couldn't put your front building wall all the way up to like your front lot line if you're in a residential zone. So not to go into supreme detail on all of these, but again, you look at your use table, you look at your bulk regulations, and now you're really drilling down into, are you going to be able to do what you want to do, or are you going to have to modify a little bit? And then, there we go. Just to make it a little more confusing, aside from your regular zoning, there are overlay zones in certain areas. So this one is actually, I stole this slide from my colleague. This is for an environmental overlay zone in the Annapolis area. So places where you're very close to the bay or close to streams and rivers and waters and tributaries, you're going to have maybe some additional regulations on top. There are also different types of overlay zones. So there's like transit district overlay zone. So if you're very close to metro, there may be some overlays, and in those cases might actually expand a bit what you'd be permitted to do otherwise, because being near transit, we try to encourage smart growth, encourage development near transit. So there's a regular zone, and then maybe you have an overlay zone too. So another layer of complexity there. And now to just get into a little bit on different types of zoning action. So in that use table, when it had a C, that meant conditional, which means it's special exception or a conditional use. Those terms are sort of interchangeable. And this, you can see the definition there. It's a use that it wouldn't be appropriate generally for that area unless you can demonstrate that certain findings can be made. And I listed an example of very typical kind of special exception conditional uses. So if you're trying to do like a commercial use in a residential zone, even if it's like a senior facility or a hospital or some home occupations and that type of thing, you might be going through this special exception conditional use process. And a practical pointer, we have clients who often say, I need a use variance. Use variances don't exist. So you're either a special exception conditional use, or you are a variance, which I'll get to in a second. And I just wanted to, on this slide, note that these are some of the findings that would need to be made if you wanted to do the special exception or conditional use. And you can see that second bullet point complies with the master plan. So as Sarah said in her remarks, that is all important. You'll see that finding in basically every type of action that I'll talk about in the next few minutes. So variances, and just kind of the easy way to keep that special exception conditional use versus variance. Special exception conditional use is for your use. The variance is for a number, so a dimensional standard. So we looked at that data table of the bulk regulations. So variances would be if you don't satisfy the site area, or you don't satisfy the setback, or you don't satisfy the height or the open space. And you can see again, the fourth sub bullet point under the last one does not impair the master plan, so all important. And what I would say too is that Variances are very difficult. We frequently have clients come to us and say, I need a height variance because they want to build higher. And you're like, okay, that's not going to work because you have to show that first sub-bullet point that there's unusual or extraordinary situations or conditions that exist, and it's not the result of the actions by the applicant. So the applicant just saying, hey, the height is limited to 35 feet in the zone. I need to build to 40 feet for it to be economically viable. Nobody cares about that. So this isn't about fairness necessarily. You have to show that your property is very strange. And now that said, between jurisdictions, it can get a little bit tricky. If you have kind of these larger, fairly sophisticated jurisdictions, they say, look, almost nobody can satisfy those variance findings. If you tend toward kind of smaller, maybe less, I'll say sophisticated, I don't know that's quite the word I'm looking for. They tend to be a little bit more flexible, maybe look a little bit more at the fairness argument, but it is a tough legal burden. So if you have somebody saying, hey, I need a variance for this, be a little bit skeptical. And, frankly, I do think you serve your clients best by being realistic with them and not overblowing your chances. So variances are tough, and honestly, we don't do too many of them. So you hear a lot about them, but I don't think they're too frequent in terms of when they happen. Rezoning, so you've got your zone, you looked at your little map, you say, well, I don't really like my zone. So there's two things that you could try to do about it. One may be more successful than the other. So who's heard of change or mistake rules? Anybody familiar with that term? No, okay. So this is, I think, again, when people want to rezone their property, this is probably the one that they tend to originally think of, which is, oh, well, a mistake was made when the county rezoned me. They shouldn't have done this. Or, well, the area around me has changed. And I think, again, kind of speaking in these bigger, more urban jurisdictions, that's a really tough argument to make, primarily because we talked about this comprehensive plan, and I think Sarah, one of her slides, said that they're typically redone every 10 years. So it's hard when a comprehensive plan is redone and properties in an area are rezoned to say 2 years later, well, there's been a change. Okay, there probably hasn't been too much change in 2 years in the land use world. So, and maybe you just need to wait out the next comprehensive plan process, and then you can get rezoned as part of that. So we don't really see too many change or mistake rezonings, although I think it is talked about a lot. It doesn't really happen too much. And then another zoning type, rezoning type, is a floating zone. So without getting into too much detail, we talked about the base zone, you had your overlay zone, and then there are these sort of floating zones that they sort of float in the air. And if you can show that your property meets certain requirements, maybe you can sort of pluck that floating zone out and place it on your property. So that's the type of rezoning case that we tend to see more often. And do I have a slide specifically on that? No, I don't. But I would just note again, under floating zone, you see master plan conformance. So it's not just, oh, I want this zone. You have to show that maybe the master plan said, okay, this is zoned residential, but in certain instances, maybe it would be acceptable for a commercial rezoning if you can find X, Y, and Z. And then you file this whole application in a very long, expensive process, I should note, to try to seek that rezoning. Excuse me. So for that reason, we don't have too many clients who actually seek rezonings by filing their own applications. What we see more often, and I think Sarah alluded to this, is when a jurisdiction is redoing the master plan or the sector plan or the general plan. That's actually when our business goes way up, because any property owners who are paying attention, and usually they do get notices from the jurisdiction, call us and say, wow, this is my opportunity to get better zoning for my property, and I don't have to file an application whose filing fees, usually at least $20,000 just for the fee. I have to pay all his attorney's fees for 1.5 years of process if I file it myself, if the county's already undertaking this, and I can just actively participate and with my land use attorney advocate for better zoning. Doesn't always work, but that's the best way to try and do it. So, all right, subdivision, you probably have heard this term. The typical notion is you have a really big area of property that's not being used for anything, and we subdivide it to put in a subdivision. So you carve it up into, residentially zoned properties, into much smaller properties than existed originally, put in a street grid. That's your typical like Levittown subdivision. For me, the funny thing with subdivision is what we end up doing a lot, for example, in downtown areas, is you have a few little small lots that are owned by maybe mom and pop businesses. And yes, a big bad developer wants to come in and redevelop. So they subdivide the small lots back into a bigger lot to make it one lot, because in general, you cannot build a building across lot lines. So your building has to, in general, fit within a new lot line boundary. So the typical notion of splitting into smaller parcels, we do a lot of taking small ones and putting it into bigger ones to redevelop. So a few more zoning type things. In a lot of areas, and in particular like urban zones, there's standard method of development and optional method of development. A standard method is where the jurisdiction kind of says, okay, you can more or less do something by right, but you're limited to something less than the maximum density and height you could do under your given zoning. So you don't have to go through as much process, but you don't get as much out of it. Or you could go through the optional method of development, but because you're asking to maximize density, maximize height, we're going to make you go through a lot of time and process too. So once you get to that sort of optional method, you're dealing with discretionary approvals where the jurisdiction does not have to give you your permit to move forward. Again, you're going to have to show that certain findings can be satisfied. And of course, we know that one of those findings is conformance with the master plan. So you can see, again, this master plan, it's not law, but it is super important. And the language, the words that are in that plan are enormously important to whatever it is you might want to do on your property. So judicial review, I mentioned, I think at the start, I have, knock on wood, and I know I'm just jinxing myself right now, fingers crossed, I have not had any of my cases appealed yet. And I don't think that's because people are scared of me by any stretch of the imagination. But I think, you know, you're coming into communities and you're representing somebody who wants to do something different. So it's change, and change is super scary to everyone, right? You know, land use and zoning, it's oddly very personal, right? Like when, you know, you guys probably live in apartments and maybe some houses and whatnot, and say you have your neighbor next door and they're making a racket on a Wednesday night because they're not working the next day, but you have work or you have school, and you're like, gosh darn it, there must be some ordinance that prevents them from making all that noise, you know, and then that neighbor wants to do something different on their property too, that maybe they want to build closer to the shared lot line with you. And you're like, oh gosh, these people are allowed to begin with. Now they're coming even closer, you know, so much as it's property and it's building, it's also very personal. And I'm sure we've all seen examples of that. And I think, you know, that's really important to recognize. When I first started practicing 13 and a half years ago, a long time, excuse me, a lot of the partners that I practiced with, you know, we had community meetings, because typically before you file applications, you're required to go in and meet with the community and send notices out and, you know, hold this meeting. And I know a lot of my partners, you know, would say, okay, it's time for the black suit, and we try to look all super, you know, professional and I guess intimidating. I don't know. That was a long time ago, and I think the world has changed a lot. I don't frankly even know that was the best approach then, but I think definitely now, you know, people talk more, we communicate more, we try to understand each other, and I think that's frankly a really good thing. So, you know, I always tell my clients, whether you're required to meet with the community or not, you want to meet with the community because they want to know what's going on, and that's fair. And you'd rather know if they have concerns. You'd rather know early on, because then you have an opportunity to talk with them. And, you know, I don't think it's ever a good thing that, you know, you didn't have any community interaction. All of a sudden you have this hearing coming up and you're wondering, is somebody going to show up and testify against me? I'd rather know, and I would rather be able to say to the board, hey, we've been talking for months now. You know, we can agree on these things, but we can't agree on these things. I think it gives my clients a better leg to stand on. I feel much more comfortable doing that. And I think it's frankly the right thing to do. And I think, again, knock on wood, for me, it has resulted in good outcomes. Litigation is enormously expensive. And sometimes, you know, the community, they just have questions that they want answered, or sometimes they just have something like, look, I really love those 3 trees in front of the property. Can you, you know, right along the street, can you just agree to keep them? And it's not going to affect my clients that much, or maybe it'll make things a little bit more difficult, but it's the thing that seals the deal. And now everybody is happy. And you wouldn't know that and be able to come to a relatively simple outcome if you hadn't been having conversations with the community. So I like to think that coming in to the community and talking to them early and often is the best way. So the judicial review conversation and the standard review and all of that and building the record is great, and it's super important, but if you can avoid getting there in the first place, that, at least from representing the property owners, is kind of the best win-win for everyone. So, and then I'm just looking to see, I made a few notes that I wanted to just, right, Sarah hit on something that I just wanted to cover quickly. Vesting. So we have clients who, obviously at this point they have spent an enormous amount of time and money in their approvals, on application fees, on consultants, on the land use attorney, and they're very worried about, am I going to try to start my construction and be told, oh no, we just changed the zoning right out from under you. So that is something that we deal with, and there's a lot of risk in the development game. I mean, some of it is just you cannot mitigate that risk. But I think Sarah mentioned that in Maryland, what you need is you have to pull your permit. You need a substantial start of construction, which in Maryland is generally putting like a footer in the ground for your building. So you can imagine that when that occurs, for my clients, that is a great day. A lot of them have a groundbreaking to celebrate that. But that is basically what protects you from like, oh, well, we're just going to change the zoning out from under you. So, and then I just have one more slide. And so this is sort of the things that private land use attorneys do. And again, I would say, well, this all sounds like very legal. So much of what I do is just really like project management, honestly, like people skills, talking with the government, talking with the consultants, keeping things moving, talking with the community, advising my clients on, hey, really, you need to go in and meet with the community. That's the best thing you can do to start off your project. And so a lot of it's just kind of quarterbacking all the various people. Yes, there's law to it, but so much of it is just people skills and just really very practical. So that's my talk. Sorry, I talk really fast. I'm from New York, but hopefully it was interesting. And Diana, I'm sure we'll cover a bit more of the actual legal stuff.
We'll find out, I guess. Good afternoon. I'm Diana Norris. I'm in-house counsel for the Piedmont Environmental Council. We are a land conservation organization based in Virginia, so I practice in Virginia. I was in private practice for a few years after I graduated from law school. I was able to work with my mentor in a very small firm. It was me and Georgia. And so we did general practice, everything from corporate law to contractual law to land use law. And it really was sort of trial by fire. I figured it out as I went. And then I shifted into in-house counsel at PEC 7 years ago. And I now have one client, and that is the organization itself. So on a typical day, I might be drafting participation agreements for volunteers to help at our educational farm, to working with our board of directors, to helping on pleadings in front of the Virginia Supreme Court. So I've learned to be very flexible very quickly. We do actually have a program for students. It's a fellowship program, and we do teach land use as well. And the first thing we do is we get out Legos. And then somebody told us we were being too old school, so then we thought, oh, maybe we should switch to Minecraft. So if your brain works that way, they're actually really good tools to figure out land use. So ELI asked me to cover eminent domain today. It's a pretty heavy subject when it comes to land use and land acquisition. I will do the best I can with 200 years of case law. So we're going to narrow that a little bit today. And what I'd like to do is we're going to go ahead and start with, as my colleague did, the United States Constitution, the Fifth Amendment, the Takings Clause. We'll talk about some early history to that clause, to the condemnation power, excuse me. Then we're going to talk, as I said, we're going to filter it a little bit into talking about what is a public use, all right? Then we're going to talk about the seminal case of Kelo and the reaction to Kelo. And then I just wanted to give you a current example of the condemnation power and how that's going through a process today that might be of interest to students of ELI. So where do we start? You should always start at the Constitution. Any good attorney should say, is this legal? Well, you start with the Constitution then. And with the power of eminent domain, it actually comes from a Latin term meaning supreme lordship, which already means it's a pretty weighty term, if you can imagine. So the Fifth Amendment comes from the 1791 Bill of Rights. So again, you want to have some context about how this power evolved. It's that private property shall not be taken for public use without just compensation. We're going to tear apart those terms a little bit, but is that a power or is that a limitation on governmental power? on the government's ability to take private property. Is it a power or a limitation? Okay. It does apply to our state governments through the 14th Amendment. And as my colleague mentioned, we do have regulatory takings, which are very common. I want to look at public use today, which tend to be more of the physical takings and that line of cases. All right. But let's just think about for a second that prohibition on taking private property for public use without just compensation. So does that mean it's a prohibition on taking private property for private use? Is that what it translates into? There is a string of cases that could say that. We'll get through that one. Okay, so early history. The first time it's really acknowledged in case law is Cole versus the United States. It's where the government condemned property for the use for a customs house and a post office in Ohio in the 1870s, okay? Immediate need, immediate use for a post office. In the subsequent years, you actually see eminent domain, the power of condemnation by the government of private property for a good portion of our national parks, the Shenandoah and Rock Creek here in DC. Shenandoah National Park's a really interesting one. A colleague of mine has done a lot of research on it and has written a book. There were entire communities living in what is now the Shenandoah National Park. Many of them were homesteaders, so they might not have had legal title to that property, creating a much larger issue with eminent domain just compensation, because if you don't have legal title to that property, will you then be compensated? Big history to the park, and it's actually quite fascinating. Our battlefields, Gettysburg, power of condemnation, private property. It was actually a railroad had private property along Gettysburg, and that property was condemned. After the 1800s, early 1900s, going into the New Deal, you see just sort of a string of cases dealing with condemnation of private property for transportation projects, water supplies, public buildings. And then obviously we get into World War II, and they're then condemning private property for national defense purposes, munitions factories, airports, okay? So there's this long history with the Fifth Amendment and with the Takings Clause, and you can sort of parse through what would be then a public use for each of those projects. After World War II, we see a really important case, Berman v. Parker, 1954, okay? This is when that definition of public use starts to maybe not shift, I don't know what the right word is, evolve, but it takes a different color to what these takings cases are, okay? In Berman v. Parker, there's a District of Columbia statute, a law, that said certain areas of the city were injurious to public health, okay? There were accusations of blight, lots of crime possibly, okay? And so the statute allowed for those areas to be condemned, okay? The Supreme Court affirmed the legislature's power to condemn for projects to beautify the community, okay? One landowner had appealed that, had gone to court over that DC statute. They actually owned a department store and said, wait, there's no blight here. I'm just part of this area, but you're going to condemn my property. And the Supreme Court of the United States said yes, that because the entire area was found to be injurious to public health, that private property could be condemned with just compensation, which is a whole nother line of cases that we're not going to get into today. So fast forward 30 years later, there's a big gap, but 30 years later, we have Hawaii Housing Authority versus Midkiff. In that case, a Hawaii Act, a Hawaii law, allowed the condemnation of residential tracts and transfer to the lessees, the people leasing those properties. They were given ownership of that land. Okay, it's a fascinating case where basically they're trying to redistribute land ownership in parts of Hawaii away from concentrated ownership. A handful of landowners owned the majority of parts of Hawaii, and so they wanted to transfer that ownership. A radical idea, okay? The Supreme Court of the United States, again, affirmed Hawaii's ability to define what is public use, and they said that this effectuated a public purpose, all right? So now we're seeing a shift. It used to be public use, public use, public use. Now it's effectuating a public purpose. Words matter in law. These matter, okay? So again, we have a gap. Fast forward 2005 to Kelo. Kelo versus City of New London. In that, we have, again, a Connecticut statute. Again, condemnation powers, 14th Amendment to the states. Connecticut had a statute whereby certain localities were authorized to revitalize parts of their jurisdictions. In this, the City of New London authorized the New London Development Corporation, it was actually a private body, to condemn neighborhoods. In this, we had the Fort Trumbull neighborhood. 90 landowners were affected. The idea was that it was near a waterfront area. They were going to create a headquarters for a large corporation. It was going to be a mixed-use development of commercial, recreational, and residential. So they were going to condemn these properties, just compensation, in order for a development of a corporation, commercial, recreational, and residential uses, all right? There was no claim of blight in this case, whereas in other cases in the past, again, they could, the beautifying of the community, making it safer, a threat to public health, that was considered blight. Blight, though, I think we're going to see shifting because we're going to have questions about environmental justice. So I think we're going to see cases come through later with that, and I hope we do, okay? A handful of landowners refused to sell. We are not going to get into this just compensation negotiation. We refuse. We are going to take this Connecticut statute to court. The Connecticut Supreme Court went ahead and affirmed and upheld all of the takings in this case. It went up to the US Supreme Court in a 5-4 ruling, okay? In that 5-4 ruling, public use, again, was interpreted as a public purpose. Okay, just as we saw in the Hawaii case, effectuating a public purpose, we now again see public purpose, negating the need for immediate use, that essential, that immediacy, right? We now see economic rejuvenation and private development, an increase to our tax base as public purpose, okay? And they justified this as saying, wait a second, we're not benefiting a particular class of individuals. So it's broader than that. And that was part of the justification. They also spent quite a bit of time commenting on the deference to the state's decisions on how they will determine and define public use. And in this case, Connecticut allowed it. They were going to uphold that Connecticut statute, all right? Well, that's not where the story ends. As my colleague here was talking about the human side of this, the corporation did not change its headquarters and move to Fort Trumbull. The development corporation was, after many years, unable to fix its funding. Most of the homes were razed, meaning they were destroyed. The Susan Kelo's home, the plaintiff in that case, her house was relocated, and that area is now still barren. There's apparently a feral cat colony. That's about the extent of it. Okay, I know. So it's an important case. It is still sort of the seminal case, 2005. That is now the string of cases we are seeing come from Kelo. But because we have that delegation to the states, there was a pretty strong reaction 44 states changed their law, 11 of which were constitutions, to deal with kilo. I'll just deal with Virginia as an example where I practice. Virginia in 2012, 2013 did go ahead and amend their constitution in a reaction to kilo. They made, I won't read this whole thing, I have bolded some language though, they made the right to the property, the right to own property, fundamental. You don't have that many fundamental rights. Owning property is now fundamental in Virginia. It's not just the property that is fully taken, it is property that is also damaged in Virginia that will receive just compensation in a takings case. The condemnor must prove why the private property is necessary to the public use or project. You can also be compensated for lost profits and lost access, which are defined under Virginia code. Okay, and importantly, as you'll remember, burdens of proof, the condemnor bears the burden of proving the use is public. It shifts the burden away from the landowners and onto the condemnor. Okay. But importantly too, in our Constitution of Virginia, we do have public service companies and railroads, sort of think about, again, traditional utilities, I would say, still have the right to condemn, okay? And that when they are providing a utility in Virginia, then it is assumed that they have that condemnation power and that it is within the public use. So I wanted to give you just a quick example of how that plays out on a national scale and certainly within Virginia. So we have something called public service companies. They are, under Virginia law, a company which delivers public services, services supposed to be essential, okay, think of these terms now, essential to the public interest, and they are then given condemnation powers. Public use, essential to the public interest, okay, so again, a little bit of a shift possibly. So we have a current project, it's an interstate project called the Atlantic Coast Pipeline. It's a 600-mile natural gas pipeline going from West Virginia to Eastern Virginia down to North Carolina, where it might connect to another pipeline. 125-foot right-of-way, about 12,000 acres of land, 6,000 acres of forest. It's a project developed by 4 companies, public service companies. That does not mean that they are public utilities, though. They can be private companies, stockholders, right? In this case, they are Duke Energy, Dominion Resources. They are private corporations. The cost of the project is under law. It can be rolled down to the customers. So in this case, there is a, if I remember correctly, a 14.4% rate of return, guaranteed rate of return on this project. Rolled down to the customers, private corporations. So that's a rudimentary map, but there you have an idea. Notice where it goes on the eastern side to Norfolk, which is a port. Some examples of pictures of what pipeline right-of-ways look like. PEC's been involved with pipelines for a while. This is a right-of-way going through Giles County, I think. This is actually a pipeline on a property that PEC owns in Fauquier County. Okay. So Congress in 1930s codified the Natural Gas Act. I don't think the Natural Gas Act in the 1930s knew about fracking and the technology that we deal with today. In our large energy infrastructure projects, we have acts that have been on the books for a long, long time. So how the Natural Gas Act plays in with eminent domain condemnation in this project is that we have a gas pipeline that's not just in Virginia, it goes across state borders. So it's an interstate gas pipeline, right? So with the Natural Gas Act, it provides that natural gas companies have to obtain a certificate of public convenience and necessity. Okay, now we have a new phrase, public convenience and necessity, which regulates construction of interstate pipelines, natural gas pipelines. If they are awarded a certificate, they then have condemnation powers for those easements, for those right-of-ways, all right? So the Atlantic Coast Pipeline in 2017 went to the Federal Energy Regulatory Commission. It applied for its certificate. It was awarded that certificate, and we actually had one commissioner dissent, which is somewhat rare, okay? And she dissented on the basis that there was a faulty environmental review. She also dissented because she said that need, you always have to establish need, that public use cannot be based on precedent agreements. Well, what's a precedent agreement? The applicant had come in and said, look, I have all these contracts with willing buyers of this natural gas, and that shows need, okay? What's coming out in later litigation is much of those precedent agreements are actually with subsidiaries and affiliates of the natural gas company. We will see what happens with those, okay? So there were landowners, there were environmental organizations, there were counties that petitioned FERC, Federal Energy Regulatory Commission, to reconsider its decision in the certificate and giving those condemnation powers, right? As we've talked about, there were due process claims, constitutional claims, questions about those precedent agreements. There were allegations that there was a deficient environmental impact statement, and the violation of the Natural Gas Act, where when you grant that certificate and you're giving them the condemnation powers, is that premature if the state has not given all its environmental permits yet? So how does that work in together, okay? So it's 2 years since the certificate was issued. The price tag has increased to about $7.5 billion for this project. It's become really complicated, to put it mildly. There have been a variety of back and forth with state permits. The National Park Service had to give a permit because the pipeline would cross a portion of the Blue Ridge Parkway. That was actually revoked. It's still working its way through the process. One of the courts vacated the U.S. Forest Service's authorization to allow the permit to cross the Appalachian Trail, the George Washington National Forest, and the Monongahela National Forest. The court actually told the U.S. Forest Service that they did not have the power to authorize that. It's a congressional power. This is obviously going to go to court, that the certificate's being challenged in the DC Circuit Court of Appeals. And there are also petitioners who have taken the ACP to court over a compressor station and alleging violations of environmental justice and air quality concerns. So these are complicated projects. You start with a history of things that I benefit from. I go to the Shenandoah Park and hike quite often. People need energy infrastructure today, but it is an amazingly rich case law about what is public use, but there is also a human side of eminent domain and condemnation, and it's very personal, as is most land use law. And that's what I have. Thank you.
Thank you so much. We'd like to open up the room now for questions in person. Do we have any questions in the room before we turn things over to the online questions? Oh, all right.
Okay. Hi. Well, thanks for the information. I'm curious to hear a little bit about your opinions on when communities flex their land use regulation tools for zoning, but specifically for like design standards, which sort of doesn't necessarily fall under, you know, safety, welfare, and health, but they still do it, and then it causes some tricky situation. So I'd just like to hear what you'd think about that.
Do you mind if I'm actually going to have to walk out in just about a minute or two to go to another meeting, but can speak to this. That is very much happening. For example, in Montgomery County, we're seeing with every new master plan that's being, or for the most part, every new master plan that's being adopted, there is a design advisory panel that is also being adopted. So Bethesda has one now. It's probably going to happen for, you know, every other area that they do a plan for. And yeah, I agree with you that it's very much outside the realm of kind of the traditional police powers. I think just on a very practical level, the way we've looked at it is, you know, trying to make nicer looking buildings is a nice goal that people can feel good about. And, you know, I think for our clients, we do really try to work with the design advisory panels. And I think in a lot of ways they have good, good ideas. And I think they do help make the project better. It probably also makes them a bit more costly to build. I think sort of from a theoretical perspective, it's been said a lot that, you know, all right, the day's going to come where someone challenges this and says, you really don't have the authority. This is completely beyond. But that's going to be a lot of time and cost and all of that. So I think just practically speaking, we're trying to just work with it and encouraging our clients to try to do the same. So I apologize, I'm going to have to run, but thank you all. Feel free to email me with any questions. So.
Do we have any other questions in the room?
Thank you guys so much. So this question is for Ms. Norris. You mentioned the idea of blight and also environmental justice. I was wondering how you see that relating and changing as we move forward.
Yeah, it's a weighty question, I would say, that the courts have traditionally defined blight in a way that ties it to public health and public safety, sort of our police powers that we think about. But when you look behind some of those cases and think about the areas that have been targeted, that these are people's homes and neighborhoods and communities. And so I think with all the change that we're seeing in our communities and societies, law has to catch up. And we're not there yet. But it's going to, I think, become more and more challenged when there are claims of blight as the justification for condemnation. And I think we're seeing that to a degree in some of our environmental justice cases. They are sensitive. It is hard to prove. And that becomes very difficult then.
Thank you. We do have a question online directed towards Sarah. What are some of the most common complaints that arise during zoning disputes?
Oh, how to answer that succinctly. Traffic. This is going to increase the traffic. I can't think of a use that is not anticipated to increase traffic. And I think it's just a general, I completely agree with Heather's advocating for communication, because a lot of those complaints are often just a lack of information, like she said. And so a lot of times people come out and they're opposed to a zoning application because they just don't really know very much about it, and they may have come around by the end of the meeting. But if they've already voiced their opposition, it might be too late to put that back in the bottle, so to speak. But the reason that Heather talked about heading up teams of traffic experts, I never thought I would be reading traffic studies when I was in law school, but you do. And then when you're working in sensitive areas, like we're all here in the Chesapeake region, environmental concerns are often very prevalent as well. So folks think that any further development is going to create negative environmental impacts. Extremely difficult to prove that development's not going to create negative environmental impacts. I mean, you know, I drove a car and took a train here today. That created a negative environmental impact. So environmental experts are also extremely important, and that's another big area that people are concerned about in that realm.
Thank you. Do we have any questions in the room, or I can continue on with online? Fantastic.
Thanks for your wonderful presentations. land use seems to be very local, allowing municipalities maybe to do some experimenting. Maybe you guys could talk a little bit about any knowledge you have about the intersection between climate change and land use, and if communities are doing anything to respond to climate change.
We're seeing that certainly along the coast in Virginia, that some localities are trying to work into their applicants for developments, how they will be dealing with floods, receding coastlines, and what are they insured, how that will all work in. So we're definitely seeing in Virginia that being worked into the processes for zoning and land use law. On a non-coastal basis, I know certainly what we do, we're looking at water quality and transportation as part of the climate change conversation. And so working through about better communities and how we can adjust to deal with climate change, and working with our localities to do so through total maximum daily loads. There's a variety of water quality and other issues that we can deal with.
Yeah, I agree with that 100%. I definitely think it's something that communities are considering now. I know the Virginia Coastal Policy Clinic has a really fascinating program where they were training planning directors and jurisdictions about how to incorporate climate change considerations into their comprehensive plans. Because, you know, like we said, those are forward-thinking 10-year documents. So it's something that people are thinking about in the planning context, and they probably should be thinking about it in the zoning context. Zoning moves slower, so I don't know if it's quite got there in the zoning context yet, but definitely in the planning context. And I mean, I know I used to do a lot of work where folks would come in with a piece of property and say, I want to buy this piece of property. Your job as the lawyer is to do the, you know, I already have the real estate agent who found the piece of property for me. Now your job is to do the due diligence and let me know if I can build what I want to build here. And I live on the Eastern Shore, so, you know, people want to build big estates on the water. They want this to be a family retreat that's going to be in their family for generations. And people would say, is this property still going to be here in 50 years? To which I did not have the answer to that. You know, and that's some serious, those are real considerations for some parts of our coastal communities.
Thank you. We have a question online that I believe came in for Diana, but feel free to answer as well. To what extent do SDGs deal with land use, and what would be done differently?
SDGs?
SDGs, I think it might be pertaining to Sustainable Development Goals or grants.
Sustainable development. Can you repeat it again?
Yes, it's what, to what extent do SDGs deal with land use issues, and what would be done differently?
I don't know. Yeah, I'm not sure about that one.
It's just, it depends on how you define sustainable development goals, because I deal with it in a different context probably than some, but with land use law. Let me follow up on one of the questions earlier that not just about the coast and somewhat about sustainable development goals. We also work with projects when there's not really a problem. We're seeing increased flooding in our area. We deal with trout habitat in the Piedmont, and many of our bridges and culverts are failing, so it blocks the habitat, so we'll then see a decrease in our fish populations. So part of what I do is I find federal funding and programs that can fund our projects to replace the culverts and the bridges. But it's not just about habitat then too. We're dealing with flood resiliency, because the moment those bridges blow out, then it creates different stream beds and habitat. So it's that downstream effect too. So planning is not necessarily just reactive. Same thing with zoning. It can be really preventative, proactive for the environment too. There are a lot of projects like that, and it's really quite fascinating.
Thank you. And I believe we have a follow-up question from that as well, or kind of goes hand in hand, is do you ever work with the BLM then in your experience?
I don't work with the BLM. We don't have funding that comes from the BLM or not. Obviously, we pay attention to the Bureau of Land Management because they own so much property, but we don't tend to.
Thank you. Do we have any questions in the room as well? Continue
No one's going to
online.
ask us about Airbnb?
Big issue.
That's a big
It's
issue.
a big issue.
I think that's one of the most, I'll ask myself the question and answer. I think it's a really fascinating land use law issue. And if you've stayed at Airbnb or if you're familiar with what Airbnb is, it's just a really interesting thing that's happening nationally, watching jurisdictions try to deal with how they allow people to rent out their homes for Airbnb. There's parts of New Orleans that are basically, according to some people, like being vacated residentially and are just turning into hotel neighborhoods. And so jurisdictions have to balance that right to use your property, right? If you buy a piece of property and you should be able to use it for what you want, but the zoning moves slow. And so a lot of times jurisdictions, you know, they've had to do some backflips to try to be reactive rather than preventative with Airbnb, and the neighbors aren't happy because you get a new person in every week, every weekend. They didn't want to move in next to a hotel. The hoteliers are not happy because they paid for a commercial property, and it's much more expensive to maintain a hotel than it is to just rent out a room in your house for Airbnb. So if all this stuff gets you going, if this is interested, which I hope we got you interested today, read some Airbnb articles or look into that. Because I think it's a really fascinating thing, and I don't think anyone's really figured out the right balance yet, but it's definitely that balancing act. It's an issue that people are trying to achieve nationally.
That shift, certainly with Airbnbs, also with accessory dwelling units and tiny houses, you know, we're seeing a shift in demographics that we haven't seen in a long time. And then planning and zoning has to then react to those changes in demographics, but also part of the community. So it's really interesting to watch how with our urban centers and people wanting to be place-based, but also near public transportation, how that is changing our land use needs and possibly ordinances. So there's a lot of change going on right now, and it's actually really a fascinating time to be in that part of law.
Definitely. Yep.
Perfect.
Thank you again. My question is kind of to what extent does your work either coincide or conflict with tribal rights and land use? Just thinking of like the pipelines or like the big culverts case that happened and kind of the tribes reclaiming their right to the land and private property owners and such.
Well, Virginia just recognized tribal rights. So I think it was last year. So it is evolving in Virginia. And I know my organization has worked with certain communities to make sure we are being in our land conservation, not necessarily our land use, but our land conservation department. And we have pretty strict archaeological standards that we work into our, we work with conservation easements with our transactions, but it too, unrecognized for a long, long time, and it needs to be part of the conversation and part of these transactions, and it hasn't been.
I have a question for you, Diana. I was interested in the case you were talking about, and if you know, I don't know if you know the answer off the top of your head, but I'm curious, what are the exact issues on appeal? The case that you mentioned that's this fall in the DC circuit?
The Atlantic Coast Pipeline, yeah. So actually FERC just filed its responsive pleading a couple days ago, I'm pretty sure. So they talk about what environmental review they did in issuing the certificate for public convenience and necessity, some due process questions, the precedent agreements they did address, their environmental issue, and some of the routing issues too, about whether they're supposed to look at alternative routes as well and decide which one would be best for the public use. And so they talked about some routing issues too. It'll be interesting. It'll be interesting to see how that evolves. Stay tuned. If you come back next year, and if I do too, I might have an update.
Thank you.
Sure.
Hi, I have a question that's sort of about the inverse of what you've been talking about. I come from a part of the country where our problem is not so much continued urban development as rural de-development. And I'm wondering if you all have seen zoning and planning catch up to that at all, if there's been, you know, down zoning maybe from residential to resource management districts or anything like that.
There is a big push in certain parts of the state to maintain that rural landscape for sure. And, you know, in Maryland, more than a few years ago now, we had a septic tier law that was passed, and it's still in place today, and it greatly curtails development on septics. And it was viewed as sort of a war on the rural parts of the state, but the whole point of it was, you know, environmental protection for some of the issues with failing septics, but also just as a way to limit subdivisions on septics in more rural parts of the state and to focus them in areas where there is existing infrastructure. And so now, in addition to your comprehensive plan, all those plans that Heather was talking about, and your zoning, you do also need to worry about that septic tier mapping if you're in a rural part of the state. So we've seen some of that, definitely.
Yeah, so I work for an advocacy organization that works for land conservation by trying to protect the rural nature of the Piedmont and smart growth. You know, there is that balance. So we do it in conjunction with our advocacy work. We also do conservation easements, which are voluntary restrictions on property. So I think there are a lot of tools in the tool belt to achieve that kind of balance. We don't see, because where I work, where the Piedmont is, we're part of where I work is still considered Metro DC, which is pretty incredible. So we don't see a lot of down zoning, but we do see a true commitment to keeping the character of the community rural in parts, have a transition area, and then locate the growth in the more urban areas, or what we call service districts in Virginia. So it's a little bit different.
Thank you. We did have a question for Diana. In Virginia law or code, what constitutes damaged land?
Oh, yeah, right. That's a great question. And there's case law out there. So if you imagine that say I have a piece of property and a transmission line is not on my property, okay? The steel girder that's not on my property, but it's on my neighbor's, and my view is completely blocked, right? And I think my property is more valuable because I had a view. Is my property damaged? Right, some people are saying yes, some people are, I'm not sure. We have a circuit court case that says, but I don't have a property interest in that view. If I had a property interest in that view, my property could have been damaged, and it hasn't gone to the Virginia Supreme Court yet, so we're not sure how that's going to evolve. If only a portion of my property, if I have a property and a business on it, and a public utility wants to come through and widen the road, they're not going to take the entire piece of property. They're not going to condemn that entire piece of property. I'm going to be left with a widened road on my property. They have to pay for the part that is just taken, the damaged part. But if I can prove that it goes beyond just that physical part, that they've damaged it in another way, whether it be through increased traffic, the noise, the dust, whatever it might be. And then you have the war of appraisers. That's when people come in and they start, you get your experts, it's expensive, and you have the war of appraisers coming in and say what was damaged and what the dollar sign is valued at. It goes on for a long time. That's big business. That's big business valuing condemnation projects.
Thank you. Do we have any questions in the room, or I can take a final question from online? All right, we have a question that I believe was directed towards Heather regarding overlay zones. However, if either of you would like to tackle this question, how do stakeholders negotiate overlays? Does one stakeholder have more claim or power?
No, no. Not to the extent of my knowledge, no. I mean, an overlay zone is just sort of there. There's historic preservation overlay zones. There's environmental protection overlay zones. So everyone within 1,000 feet of the water in Maryland has a critical area zone. Then you have 100 feet of buffer in which you can't do anything right in front of the water. And those things just apply to your property. The floating zones that Heather talked about, that's cool. That's the future. So if Euclid's your grandma, floating zones is like the millennial of zoning. That's like what everybody's really into right now. And they're great because jurisdictions can say, hey, you know, when they're in that planning process, say, we want more mixed development. We want more developments downtown that are commercial and residential because we think there's young people who wouldn't mind living above a store. That used to be how things were, and then it changed and everybody moved out to the suburbs. But we don't like all those people living so far out because the roads are expensive. We got to bus all those kids to school, and young people don't think that's cool anymore to live in Rolling Hills subdivision 5 miles outside of town. They want to be in town, and so we want to allow a developer to build that type of mixed use. But we don't really have anybody here. There's no application, but let's put that zone in our zoning ordinance and say, here's a mixed use commercial residential floating zone. And if that developer comes and has that idea and we think it's the right place and we think it's the right project, we'll allow that zone to be floated and we'll allow those changes to occur because that's the kind of development we want.
Thank you. If there are any other questions in the room? No? With that, I would like to thank our audience for joining us today and for your great questions. We hope you will continue to think and learn about land use law. You can stay up to date with our summer school series on our website, eli.org. And please note that we will reconvene on July 9th, not next Tuesday, for the Clean Air Act. An enormous thank you to our brilliant panel, Sarah, Diana, and Heather in spirit. Your vast knowledge in these topics have been fascinating and informative. We're so glad to have you join us today. Thank you all once again.
I'll send you that file this one.
Thank you.
Yeah, you can put
We'll leave that at the beach next week.
Just what you want.
Yeah,
Yeah, sure.
Do most of the jurisdictions post